Call to order the April 18th, 2024 Subdivision and Development Appeal Board hearing. My name is Andre Gianandrea, and I will be the chair of the hearing. All questions and comments shall be directed through the chair, please. At this time, I'll ask the board members to introduce themselves, starting from my left here.
Larry Bowen. John McClark.
Councillor Tanya Faubert.
Thank you. Will administration please introduce themselves?
Cheryl Hyde, SDAB clerk.
Ben Staver, municipal clerk.
Sarah Jones, SDAB clerk.
Riley Weldon, acting manager of planning and development.
Andy Asarte, manager of engineering.
Annika Drust, planner.
Mike Stasiak, community development engineer.
Okay, thank you.
Oh,
Oh, sorry, we have someone joining us on Zoom here, if we could get an introduction there as well.
yeah, and Janice Zagreus, I'm the lawyer for the SDAB.
Thank you. To the board and administration, are any additions, deletions, or changes to the agenda at this time? No changes or additions from the board? Anything from administration? I move that the board approve the agenda as presented. All those in favor? None opposed, motion carried. To the board, any additions, deletions, or changes to the record of proceedings for the March 14th, 2024 appeal that was held? I move that the board approve to the record of proceedings for the March 14th, 2024 SDAB meeting as presented. All those in favor? Opposed? That was carried unanimously. Approved. Today, the board will hear an appeal by an appellant of a decision by the Development Authority to approve development permit application PL 2023-0037 for accessory use and accessory dwellings at number 1 Silvertip Trail. Will the applicant please approach the podium and introduce themselves?
Good afternoon, Mr. Chair, board members. My name is Rick Roll. I'm representing the applicant as well as Basecamp, the developer property owner, and I've got a team with me. If you'd like me to introduce, the main speaker will be Byron Fistecki.
Thank you. For the applicant, do you have any objection to any of the board members present hearing this appeal? No. Thank you. Will the appellant please approach the podium and introduce themselves?
Good afternoon, Mr. Chair, members. My name is Cheryl Elgert. I'm a lawyer. I practice with Elgert Law, and I represent Stone Creek Resorts, Inc. With me here today is Karen Finley, Senior VP of Resort Development, John Third, VP of Community Relations. With B&A Planning, I have Ken Venner and Marisa Koop. And with Bunt Engineering for Transportation, I have Amrit Uppal. And I have no objections to any of the board members.
Okay, thank you. You just answered the next questions.
Thank you.
Does anyone in the audience affected by this appeal object to any present board members hearing this appeal? I'll just run through some of the procedural matters. Before we hear the evidence, there's a procedural matter the board must address. The appellant has requested a 1-month adjournment of the hearing to allow the town of Canmore time to provide multiple requested historical approvals and reports related to the subject property and the Silvertip ASP development. All affected parties now have an opportunity to provide input on this request specifically. Does the appellant wish to speak to the request for adjournment?
Thank you, sir. Again, Cheryl Elgert for the record. Effectively, so there are two different pieces here. One, if we are proceeding with the appeal as we are appealing the permit in toto, then we require the additional month to acquire additional documents from the town of Canmore. We have been wholly unsuccessful in acquiring background documents With respect to the approvals for the direct control district, even the development permit on the property. So for example, the planning report states that a hotel was approved with an accessory use restaurant. In fact, there's no evidence of that. So we don't know if actually the restaurant is a principal use and the hotel is a principal use. We just have no evidence on that right now. So it's, those are two of the things, and we have a response. I don't think the board really requires it, but I do have the response from the town on that. But there are other documents that we've requested that we still don't have. And then in addition to that, there's a possibility, and we are hopeful about resolving, as you will have seen from our submissions, the plans. We have not seen any revised plans. So, and there's some sort of questions about how the details will work out. Overall, I will say that my client is very in support of this development. It's simply a matter of how the edges fit together and what the loading of the site is and that sort of thing. So we just need a little bit of time to get this sort of settled out. So those are the two reasons why we would seek an adjournment. And I have, some time ago, I canvassed dates with Mr. Grohl. Maybe I'll just allow him to speak to that, but my understanding is that we're talking about sort of the third week of May. I have an absence. I will be gone from out of the country from the 25th until the 3rd, and then after that, so.
Thank you.
Thank you.
Does the applicant wish to speak to the appellant's request for an adjournment?
Mr. Chair, thank you for allowing us to speak to this adjournment request. Byro will have some additional comments to make. First, my clients, the applicant, as well as the developer, property owner, Basecamp, objects to this adjournment request. We believe that the grounds for the request are unreasonable in the circumstances. Ms. Elgert is correct. We've tried to reach a resolution between the parties. Unfortunately, we didn't. That's why we are here today. The reasons for her adjournment on the grounds that she's seeking additional documents from the town, we believe are pertaining to development permits that are just irrelevant. She keeps mentioning an existing development permit, that there is no evidence of a permit has been issued. Our understanding, a development permit has been issued for the existing development on the site, but that the town is not able to produce the record of the development permit. My view is that the onus is on other parties to demonstrate that this so-called, that there's no records of any approvals for this hotel. This has existed for many years, and we believe also the existing development permit for the existing development, including the current accessory use as a restaurant, is irrelevant. It's outside of the scope of the appeal and the application before you. I now, with your permission, like Mr. Fizeki, to elaborate on their objections, if you allow that.
Certainly. Yep, please proceed. Thank you. Good afternoon.
Good afternoon, members of the board. Mr. Chair, for the record, my name is Biral Fizeki. As Rick mentioned, we are opposed to the adjournment. I believe I can show how the appellant is, in my view, simply using this as a delay tactic in an effort to cripple our business. Sadly, because of friendships, both personal and professional, the appellant knows what's at stake for us. We've shared with them how much money we've raised to build the spa. We've explained to them the urgency and the importance around not losing a construction season. We've provided them with a level of vulnerability that I would never expect friends to take advantage of. And I go back to March 2023. Again, in my view, there's been a constant pattern of Stone Creek giving us hope that we're going to be on side, we're going to reach an agreement, and at the very last minute, it's one more thing that we need to kind of show up for. Now, let me take you back, because I think the details are very important. Last year, March 2023, I met with representatives of Stone Creek. At that time, they voiced concern about a large spa going ahead at the base of Silvertip. It was a competing spa, I get that, and I offered immediately to cut the spa in half, literally. So it was clearly without a doubt that this would become an amenity to the hotel, and we amended all our applications as such, and that seemed to appease the concerns. The appellant was never in the dark about what we were planning to do. You know, even today, and since the opening of the hotel, we've had billboards in the hotel's lobby showing what our plans are. I know for a fact members of the Stone Creek team have seen these. Not only that, we've stripped and graded the site last fall. Again, not once was there a phone call to us saying, hey, I noticed you stripped and graded the site. Can you just share with us what the final plans were? We were approved February 21st. On February 27th, during a lunch meeting and a discussion with Stone Creek representatives, I explained where we were at in the process and transparently sent them all our information that they asked for. They did raise a concern then. They raised a concern about the off-site obligation imposed on RDP, which is the narrowing of the laneway. Now, we immediately set up meetings with the town. So we had head of engineering, head of transportation, our planner. Am I missing anyone? It was a full house. It was very impressive. And I was so impressed at the level of willingness on the town's behalf to come to the table to solve this challenge. Everybody acknowledged that this is an off-site enhancement that was impacting RDP. And at the time, no one was talking about the elements of the spa that were creating any heartburn. This was an issue of an off-site enhancement. Now, regretfully, it took till the very last day for us to see an actual submission of an appeal. So again, a delay to the very last moment. And at that last moment, there were 5 items on the list now, not one, not an off-site enhancement. It was 5 items, and they kind of wove together things that were on the site as well. Now, we immediately went to task because there are our friends. Long history of friendship. So we immediately went to task to solve all 5 items. And we chipped through all 5. Like, if we get to present today, you will see there's resolution on every single item. Yes, some details are omitted, and yes, we would require the town to support some of the ideas, which they verbally have. So we would have to trust the town that they would be willing to play, to agree to some of the things that we've been discussing. And to date, they've shown that willingness. So yes, I would be willing on behalf of Basecamp to trust the town. That's what developer and town relationship should be. It shouldn't be a relationship of animosity. Now, last Wednesday, we finally came together. Ourselves and Stone Creek in their office, we agreed to bring counsel, we sat down and we went through every single line item. We came to agreement on every line item, including the very last one about accessory use. We came to agreement when I finally turned to Mr. Turcotte and had a candid conversation about what they were trying to achieve through their concerns around accessory use. And we resolved it at that table. We left that meeting feeling really good about ourselves. We left that meeting agreeing that we would submit to SDAB a mutually agreed upon strategy that all it required was the town's buy-in. We contacted the town. The town agreed to say, look, we won't oppose that solution. Like if that's not a home run, I don't know what is a home run. And then things started to change as of last Friday. Then there are questions about wanting to see our financial statements, wanting to see our operational plans, wanting to see elements of our business strategy. Flash forward to 10:30 last night, I realized that this is not about a road. This is not about having enough trees or too many trees. This is not about screening. This is about having a competing spa in the neighborhood. I joined Basecamp a little over a year ago. I've been in this industry 35 years, and I have never had an appeal on one of my projects. And I truly do wear that as a badge of honor. Funny enough, Basecamp has never had an appeal on one of their projects. My focus has always been, and Basecamp's focus has always been, to contribute to the communities we develop in. And I know that sounds really apple pie motherhood statements, but it's true. We live by those values. I've spent the better part of the last month negotiating in good faith, accepting everything that's been thrown at us, including paying for an additional length of a trail system, because in the end it does contribute to the region and does contribute to the town. So those are things we can get our head around. My plea to this board is to not grant an adjournment. Let the appellant provide reasons, specific reasons as to why the extra reports that they require are so fundamentally important to the, to the case at hand. And I think you'll find, and you'll reach the same conclusion we've reached as of 10:40 last night, that this is not about trying to have a solution. This is about trying to stop a spa from going ahead. It's a delay tactic, so we can be pushed out of this construction season. And I know those are strong words because they're close friends of mine, so it hurts me to say that. But I am shocked at the level of commitment we've given both the town and our friends at Stone Creek, yet we're still asking for an additional 4 weeks. And you gentlemen and Madame all know the importance of 4 weeks in a construction season. So I trust this board. Regardless of the outcome, I trust the board, but I don't think the appellant's merits for adjournment are worthy. Thank you.
Thank you. Just a quick pause before I move forward. Do you have everyone's name for the record that's spoken so far?
Yes, thank you for asking.
Okay, thank you. Does the administration wish to speak to the request for adjournment?
Thank you, Mr. Chair. Town administration does not object to the adjournment if time is required to obtain the information that is requested. We have been searching due to the length of time for the permits requested, over 30 years, I believe. It has been difficult to locate the files that have been requested, so it is reasonable to allow additional time to obtain those files and present them to all parties.
Thank you. Any questions for administration from the board right now? Does anyone else present wish to speak to the request for adjournment? Okay, at this time, the board will meet in a closed session to consider the request. We'll ask the members of the public to wait in the atrium until we call back to order, please, so we can confer with our legal counsel as well. Thank you. I'll call the hearing back to order at this time. In consultation with legal counsel, the board has a few questions to address before arriving at a decision to grant or not grant the adjournment. If I'll allow you to go.
Sorry, so this first question is for the appellant. I'd just like to know why you think these documents that you've requested are relevant to your appeal.
So I understand that the development is related, it's proposed for a specific part of the plan, for a specific part of the parcel. However, the entire property works together. We don't know what the permanent conditions on that use were at the time. So we don't actually have a basis on which we're operating. I was trying to do some assessment about what would be the situation if the restaurant, because the baseline traffic and parking requirements are hotel, according to what we're being told, right? The visitor accommodation. So that's 1 stall per room. And accessory use is, it can be in use, but so long as it doesn't substantially increase the traffic, the intensity of the use of the site, there's one other, the patronage. So right now, we have a restaurant that used to serve the hotel primarily. It's now being changed, so it's, I can book a reservation on OpenTable. It's being heavily advertised. So I'm trying to think about how the parking and the traffic work and whether or not things are appropriately suited, right? So that does depend on what the previous permit was. So, okay, so let's just say that we can't get it. There are lots of situations in which we can't get the permits. So then we typically will take a look at the existing land use bylaw and say, how would it fit? And actually, it looks like it fits okay. So still one parking stall per room. In addition to that, then there's a question of the restaurant. So if we say that the restaurant is a principal use, then we need gross floor area for the restaurant. That's how it's measured in the land use bylaw. So I requested that information just to be able to sort of eyeball what's going on, and the answer was that it wasn't relevant. So I can't even come up with a sort of idea. So we have no as-built plans for the materials. I've looked online and I've seen advertisement not only for an outdoor spa, there's a separate indoor spa with manicures and pedicures and this sort of thing. So what looks like is happening is a real intensification of the parcel, both in terms of traffic and in terms of patronage and in terms of intensity of the use of the site. And we can see the intensity of the use of the site go up by the removal of all the natural landscaping and the replacement with outdoor amenity spaces and this sort of thing. Now, I need to be really clear here because I'm talking in a way that is very sort of doubtful about this, but regardless of the sort of overall, we know that the property, it's a big property, it can be intensified, and like there is some space. But the only question is really around things like the traffic and the parking and contribution to, like that intersection doesn't work. So the question is, and that's in the town's documents. So basically, we need some background to have the foundation for the discussion, and then we build it up to ensure that this actually works not just for the purpose of a paper approval, but that it works in fact. Everybody in this room has been in this town at high season when things are not great in terms of transportation. So for this very important site that is the entry to Silvertips Resort, for this site not to work, for there to be backup onto Silvertip Trail and Palliser, for there to be parking on the street on Palliser or on Silvertip Trail because there's no parking there. For these kinds of things not to be thought through properly and to have the background and then to build it up from there, we're seeking, it's sort of like we've got the ingredients, some of the ingredients for the cake, but we don't have the cake yet. But, you know, last night there's been lots of discussion about a shorter adjournment, this sort of thing. It's our hope to be able to come back sooner to get something adjusted and get it approved by the board. But if we're going to be going to a hearing where we're actually having we're going to be making submissions and having to get into it and being fighting about it, then we need a bit of time, and we need some time to get the documents and review the documents. And, you know, I have the Silvertip ASP. I don't have the Silvertip ASP planning report. I don't have the original direct control bylaw. I don't even know when it was approved. And this town has actually been amending direct control bylaws where, you know, the courts say that a direct control bylaw is frozen in time. Like, there's a lot of stuff going on here. I need a bit of time.
Thank you. Any questions from arising from that? Okay, thank you.
Thank you.
Does the applicant have any submissions on that? The relevancy of the...
Thank you for asking the question. In response to and you heard that in my introduction, saying we fundamentally disagree about what the scope of the application is. And you if you read the report, and I trust you have met the details, there are extensive submissions from both parties. Ms. Elgert has a different opinion on that. Somehow, if you make an application for adding an accessory use to an existing development, that somehow you now then entitled to revisit and reopen and reassess the approval of that existing DP. There is actually some case law. Unfortunately, I don't have it with me because I didn't expect that this question would to be asked, but there is a case called Tsung Holdings in Calgary. Your board solicitor is very familiar with it. It was a case where somebody on an industrial site wanted to add an additional use. An appellant, a competition, appealed that because they objected to the use, the outer body use, to the rest of the building. And then they wanted to have an argument about the existing parking that was already approved on the previous permits, and to have that all being assessed. The court says no. When you make an application for a change of use or an addition to an additional use to an existing development, the scope of a development permit is only limited to the additional use only. And that is where this is about. The document she's seeking is all about the history of the approvals for this site. Previous planning documents, previous ASPs are irrelevant for that. And my client has an existing use, what is in accordance with the land use bylaw. It's not a non-conforming use. It's not a non-conforming building. All they are doing, adding an accessory use, what actually under the land use bylaw, and if you read the report of your administration, you will note an accessory use does not require additional parking because it is approved as an accessory use. They want to revisit the parking. That is not within the purview of the development authority nor on appeal by this board. And that's why we're saying the reasons for asking those documents are not relevant. So that's all I have to say, and thank you for the question.
Okay. Thank you.
With permission from the chair, I'd just like to add to that.
Certainly.
There's a lot of smart people here, so I just want to turn away from what the bylaw says and this and that, and focus on the pragmatic side of things. We run a hotel. We would be literally not shooting ourselves in the foot, but cutting off our entire leg if we allow day users to come in, fill the spa by driving to our site, for our first hotel guest to come and check in, or try to check in, but they can't even park their car. You can imagine the challenge that would present to us as operators. Now, the solution would be, okay, I'm going to go park on Palliser Trail. Well, we know that that's a direct bylaw infringement, which would cause yet another problem for our guests. So it wouldn't take long for social media to completely chew us up from an operational perspective. I understand the concern. I truly do. I go back to saying, you know, there's going to be some bridge building. We're friends. And both sides keep saying that. The piece that's missing here, I think, is the town is in the process of evaluating their transportation strategy. They've been transparent at that. And they were the first to say, oh, okay, well, listen, what do you got? There's time to sort this out. Base Camp is not building the off-site enhancement day one. They're not going to narrow the road day one. Let's meet with your engineers. Let's talk about this. This discussion today has nothing to do with the spa, and that's the frustrating part. If I sound frustrated, that's why. We agree on all elements. In my view, we agree on all elements other than this road narrowing, and lo and behold, the town, the appellant, and ourselves have all stepped up and said, money's there, plan's there, we're willing to accommodate, everything's good. But we're pushing another 4 weeks, which is my concern, because there will be time after that 4 week as well. And that's, you know, it's tough. To be a small business, it's tough to lose a full construction season.
Thank you. I believe 2 additional questions arose from our discussion. Oh, please go ahead.
I think that we're sort of veering into sort of meta information, but I wanted to just come back to the question about conforming. So the board heard that we don't have a development permit that establishes whether this was a hotel as a primary principal use and a restaurant as a principal use. What we have is a representation that this is a hotel as a principal use and a restaurant as an accessory use. Mr. Grohl mentioned that there's not a non-conforming issue. I just caution that so we have, as I said previously, the hotel, the restaurant used to serve the hotel. The restaurant is currently being marketed to the general public. And so there is, I think, a live question as to whether that restaurant remains an accessory use. And if it does not remain an accessory use because it is it is not directed toward the use of the hotel, it's not accessory to the hotel so much as it is facing everyone, then it would be a non-conforming use. So if it's a non-conforming use, Municipal Government Act Section 643, and I think it might be sub 4 or sub 7, says that if there is a non-conforming use on the building, on the property, and I just want to stop here, it would be a non-conforming use because the direct control district does not list eating and drinking establishment as a discretionary or permitted use. So because that use is not in the direct control district, if this wasn't approved as a principal use and it is an accessory use and it is not being really accessory to the hotel, but it is really serving everybody else, then the Municipal Government Act says that if you have a non-conforming use, you can't build any additional buildings on the property. I can find the section for the board if the board would like that, but I just thought I'd better pop up and let the board know that.
Okay, thank you. I'm just going to turn it back to my colleague, John, here to finish with the questions that arose from the in-camera session at this time.
Sorry, I can't hear you.
There's a few other questions that arose from our deliberations here.
So this question is also for the appellant. When did you request the documents?
We actually have a listing of all the contacts that were made over time to get the different documents. They were made I believe that they were made even in advance of the appeal being filed. So just have a moment, please.
Okay. Go ahead, John.
So are you?
And sorry, there were some that were requested previously, and then I reached out to the town solicitor about my concern that the documents were not being produced like I didn't have any sense of when I was going to be getting the documents. And then he was on vacation, and then he got back to me after vacation. I'm going to say, I think that was maybe the 8th.
Mr. Chair, if I can, sorry to interrupt. We do have a date that we received the application for a complete list of documents that have been requested, and that date was April 5th.
April 5th?
Correct.
Okay, thank you.
You're welcome.
And I should just say that went in after I'd previously sent, I'd previously corresponded with Mr. Driedzek, and I can just pull that up here. So I have from B&A, so it was previous to March 22nd, because on the 22nd of March, B&A received an email from somebody in records called Topanga regarding a notice of incomplete application. And of course, we weren't making an application. Then there was an email asking to confirm whether that was about our documents, so that it was prior to March 22nd. But I actually, can we have the different?
So the emails were between you and the
Town,
the town?
not me. I mean,
Someone-
my correspondence was with Mr. Driedzek.
Karen Finley with Stone Creek Resorts. Perhaps to the question, I just wanted to say that it was our hope to resolve this before making an appeal. So we did reach out to the town sometime in between when we saw the posting. And we did reach out to Base Camp sometime before, after we saw the posting, to get information and to have some information. Beryl mentioned that we had met with the town. We did that before we even filed the appeal. What we felt was we just didn't know enough. So we filed the appeal, because if we didn't, we wouldn't have an opportunity to have the furtherance of discussion. We would just be assuming the approval. And so in that time frame afterwards, there was a lot of back and forth. And on our team, we have B&A, which is our planner, and they would have gone back and forth with the planners. I myself was in touch with people at the town. We were in touch with Base Camp. We had meetings. I mean, I think there was genuine attempt for all parties to come to resolution before today. And there was a lot of correspondence. And so we have written down the list, which I've given you time to find. But to the spirit of it, certainly there has been a lot of back and forth. There has been a lot of sharing of information with the intent to come before you today with a completed arrangement that we could all stand behind and say, we understand what this is going to look like. We understand how traffic impacts are going to be. And we just simply didn't get there. But the correspondence has been frequent, so the list might be long. Thank you, Chair.
I just generally want to know, when did you first start to ask for these documents that you're now waiting on?
So I personally wrote about this on the 27th because B&A was having trouble getting any response. And I mean, the hearing was on the 18th. This is already the 27th. We still didn't have the documents. But the requests were going in prior to that.
Okay. And is that consistent with the town's recollection or records?
Through the chair, yeah, there was correspondence prior to the 5th with regards to requests for the information. These requests go back to, I believe, yes, the 27th of March. So that is consistent. We received a comprehensive list of the documents that were requested on April 5th, and then began to search for those documents from April 5th.
Thank
So
you.
in any event, we have the just correspondence on those documents 5 days earlier to that. So the documents were requested by B&A prior to March 22nd, so that's the two pieces of information. I was retained on, I think, the 14th of March. No, I would have been maybe the 15th of March. So we were trying to figure out if we could just sort it out beforehand. So anyways, before the appeal was filed, 2 of the documents were requested. We have had feedback on that the town can't find the documents. The other documents have been, I requested on the, whatever day I just told you, I think the 27th. And since then Adam came back from vacation, and then he responded in, I guess he didn't pass on the request to his staff members, and so we had to make a separate, different request for those documents.
Okay, thank you. Anything further? Or did we satisfy the? Sorry.
So the third question is for the town administration. What's the likelihood of, first of all, what efforts have been made to locate these documents? And where do you think they might be? And what's the likelihood of, if we did grant an adjournment, what's the likelihood of locating those documents anytime soon?
Through the chair, yeah, it's a really good question. As I mentioned before, the challenges for administration to obtain the documents really simply is because of the age of the file. These documents were produced multiple decades ago. We have, since that time, scanned the documents into separate digital files. We have looked through those digital files. We are continuing to look for those files, and we have found some of the documents that are related to those files, but we haven't been able to locate all of them. So what I'm saying is that there was challenges basically because of the length of time and the process of converting the actual hard copies to the digital copies, and then the filing of that in our database. So to answer your question of the likelihood, I really can't say. We will continue to look and continue to produce whatever we find.
Okay. Thank you. I think we have some other questions, right? Anything else, Jill? Okay. Tanya?
No, I think I'm okay.
Good. Okay. Okay. At this time, we're going to go back in camera with the information that surfaced after coming back. So appreciate everyone's patience. So we'll adjourn again. with a suggested hearing date of May 9th. If that is suitable for both parties, we can have a quick discussion on that to compare schedules. Does that date acceptable to the applicant? I think, yeah, sure, take a moment and let us know.
Thank you, Board. Unfortunately, on May 9th, I'm occupied with a full-day hearing that same day in Calgary. So that date won't work for us.
Okay. And the appellant?
I'm
Alternate?
available.
Okay. Is there an alternate date that works for you, sir?
I think Mr. Grohl has a bit of a busier schedule, so better to ask him.
Okay. Yeah, if we could, we don't need to establish that right this moment. You can coordinate with the town admin and yourselves in this setting. Please.
Thank you. To the chair, we would accept the May 9th date.
Okay, that,
Yeah,
you can
we
make
would-
that work.
We're
Okay.
going to continue to work with the appellant
Okay, thank
between
you.
now and then, and hopefully come with a smiley
Thank
faces.
you. So if that's suitable for both parties, I'll turn that over to town for scheduling. Okay, okay, thank you. We stand adjourned at this time. Thank you, everybody. I believe we do. If we, motion to adjourn?